order to be found guilty of the crime. And secondly, it returns the penalty for illegal voting from a misdemeanor to a second-degree felony. It's been a felony offense for almost 50 years, and Senate Bill 1, an amendment, made that change. And so that's what the bill does in those two pieces. It has to do with the mens rea requirement to correct an aberrant ruling by the Court of Criminal Appeals, and it cleans up an amendment from 2021. That's what the bill does. You guys are familiar with these issues, but the Fort Worth Court of Appeals wrote about this in 2020, and they reviewed a case about the crime of illegal voting. And they discussed a case on basically the same statute from 1888, 130 years ago. So going way back in Texas jurisprudence, this is what the mens rea has been. And when the Texas Court of Criminal Appeals decided Thompson in 1888, the illegal voting statute was substantially the same, the court says. And it said this: if the defendant had been convicted of an assault with the intent to murder, as alleged in the indictment, and if he knew at the time he so voted he had been so convicted, such knowledge of his conviction would be equivalent in law to knowing himself not to be a qualified voter. It has to do with what my state of mind is when I commit the offense of illegal voting. Illegal voting is not just about voting when I am not eligible to vote. It's also about casting a vote belonging to someone else. It's about preventing someone else from casting a vote or marking their ballot wrong. So a lot of offenses are covered by this. We want to make sure that the law is clear on what the legal state of mind is required to be, and the penalty is restored to the felony. It has been a felony for almost 50 years. I'm sure we'll be able to talk in more detail, but that's what the bill does in those 2 points. And I move to suspend the Senate's regular order of business.
Senator Menendez, for what purpose?
Thank you, Mr. President. I'd like to ask Senator Hughes some questions about his bill.
Senator Menendez, you're recognized for that purpose. Senator Hughes, do you yield?
And of course, I'll yield.
Thank you, Mr. President. Thank you, Senator Hughes. I was listening to your layout, Senator Hughes. I have a couple of questions, and I'm just trying to understand, in the event that I'm very concerned that we can ensure that those who are simply making a mistake and voting under the belief that they are registered to vote, how will they not end up with a second-degree felony if they are under the belief or they believe that they are registered to vote? I'll give you an example. There are people who, you register high school students if they're going to turn 18, I think it's 2 months before, if they're 17, but they're 2 months before the election, they're allowed to register. So what if they're 2 months and 1 day, and they came in and someone said, who's going to turn 18 in the next couple months? Is it your intent to make an 18-year-old or a 17-year-old in 364 days a felon?
Senator, great question, and the statute itself addresses the concern. I'm glad you brought it up, and I should have mentioned this in the layout. So section 64.012, illegal voting, a person commits an offense if the person knowingly or intentionally votes or attempts to vote in an election in which the person knows the person is not eligible to vote. So in the situation you're describing, the person, it's a question whether they know they're not eligible to vote. Now, for example, if I'm a felon and I've had my voting rights taken away because I'm a felon, I know I'm a felon, then I've got a problem. If I know I'm not a citizen and I try to vote, I've got a problem. So that's really what this amendment is about. The situation you're describing, I believe, is covered by the statute.
By the new bill that you're proposing today?
I'm sorry, one more time.
By the bill that you're proposing today, you believe that it covers a simple mistake?
The bill that I'm proposing today would have, in your situation, would affect only the offense level if a judge and a jury found the person did that knowingly or intentionally.
So, okay, so if this bill passes, goes to the House, passes, gets signed by the governor, becomes law, then we have to be careful that all 17-year-olds who expect to be 18 by the time of the election, that they are, or if not, they could be taken up potentially on felony charges under this bill.
Well, Senator, this offense of illegal voting, which includes the laundry list we went over, was a felony for almost 50 years before 2021. So we wouldn't want to give folks the impression that we're making some radical change in the law. We are restoring the law to where it was 2 years ago. I think that's important, and I should have stressed that when I first moved to suspend.
So if I read your bill correctly, it's going to be a second-degree felony, punishable by imprisonment for a term up to 20 years. Is that correct?
A minimum of 2 years. And so the difference between a second degree and a third degree has to do with the upper end. The minimum is 2 years on a second degree and a third degree. And so the court has discretion to stay at that end if they would like to. We can go over some other offenses that are relevant they're comparable if it's helpful to you. But again, this offense has been a felony for almost 50 years. In 2021, a late amendment on Senate Bill 1 changed the offense level, so the part of the bill you and I are describing would merely return that to the felony offense that it was in 2021.
Senator, when I asked the question, I said for up to 20, you replied in your answer that a minimum of 2. So am I to assume that it can be 2 to 20? Am I correct?
So 2 to 20 for a first degree, 2 to 10 for a second degree.
2 to 10, okay, for making a mistake for voting. Okay. Senator, I understand that the legislature lowered the penalty for illegal voting less than 18 months ago in Senate Bill 1. And that bill, as you know, was heavily debated here and negotiated last session and through 2 special sessions. So why is increasing the penalty, or the way you put it, bringing it back to what it was, why do you think it would not be appropriate to keep the change or why do you insist that we should bring it back to a felony?
Senator, that's a great question, because as you'll recall, Senate Bill 1 was heavily debated on this floor. You and I did a lot of that. Many members participated. This particular issue was not treated that way. It was very late in the session, and the legislative history will show that over in the House toward the very end, when the bill had come over from the Senate, before they sent it back, this amendment was added. This was part of an amendment that was not discussed when the amendment was laid out. And so I think you'll find anyone would agree, whether you love this amendment or hate it, this issue was not debated, was not vetted through the normal legislative process last session.
Senator Hughes, this will be my last question for now on this bill. My concern, and I wonder if you share this concern, that creating this or returning this offense to a felony status, that on the first offense has a 2 to 10 year penalty, potential penalty, would potentially deter people from voting, especially if they believe that they're now eligible to vote. Or what if does someone make a mistake? If, let's say, they take their elderly parent, my mom's 87, she used to take me when I was 18, she and my dad, and now we take her, my father's deceased, to vote. Do I create a penalty or a felony if she says to me, ask me a question about one of the 2 people on the ballot? I mean, is there a potential for that to occur?
No, Senator, nothing in this statute about assisting a voter. As you know, that's addressed elsewhere in the election code.
Right.
Nothing in this statute about assisting a voter or anything like that.
Sir, I'm concerned that by taking the mens rea out, the knowing requirement, we're going to run the risk of criminalizing and therefore deter people from wanting to vote. And so while you have been very gracious in your answers, I believe this returning of this penalty is disproportionate to the potential mistake, and therefore I will be respectfully voting against your bill. Thank you, Senator. Thank you, Mr. President.
Thank you, Senator.
Senator Hinojosa, for what purpose?
Well, Senator Hughes yield for a couple of questions.
Senator Hughes, do you yield?
Of course, I'll yield.
You're recognized.
Thank you, Mr. President. And you know, Senator Hughes, mens rea is the intent to commit a crime.
Yes, sir.
An evil mind. They've been with us for centuries. Would you agree to that?
Yes, sir, definitely.
So here, what we're doing is adding additional elements that are necessary to prove to mens rea that there was intent to commit a crime and violate the election code?
Senator, I believe that's the heart of the matter. And you know how this works. And again, your law practice is more advanced and developed than mine. But here's what we're driving at. Under the law today, if I break into your house and I take your stuff and I intentionally knowingly know it's your house, I'm taking your stuff, I'm guilty of and I'm convicted, I'm guilty of the crime of burglary. I don't have to know that burglary is against the law. I just have to know that I came in your house, broke in your house, and took your stuff. That's the idea. So if I'm aware of those conditions, if I know that I have voted in another state in this election, if I know that I am a felon, I've not had my voting rights restored, if I know that I'm not a citizen and thus don't have the right to vote, I can be held accountable for illegal voting. So you're right. It's all about that mens rea. You're exactly right.
But here, what's happening is when you describe burglary, I think that just makes common sense and morality. It's involved in many of the criminal laws. And if I may point out, probably we have, I don't know, I think 1,700 criminal laws in the books. Out of that, only a small minority, I think 300 criminal laws are in the penal code. So how are people supposed to know that what they know is a crime? There's certain knowledge that they have that's a crime.
Well, I'll say this statute on illegal voting, at least since 1888, has been interpreted this way. And I'll read to you what the court said in Thompson. They said, if the defendant had been convicted of an assault with the intent to murder, as alleged in the indictment in this case, and if he knew at the time that he so voted, that he had been so convicted, such knowledge of his conviction would be equivalent in law to knowing himself not qualified to be a voter. So the law for a long time has said, if I know about those conditions that make me ineligible, then I am guilty if I then attempt to vote, if I vote.
So if I go vote, for example, and I think I am eligible to vote in that particular election, and I'm actually not, even though I know that I live in what I think is a legal vote. If I get pushed to a provisional ballot, and then I get to be proven wrong, could I be indicted under Senate Bill 2?
Now, Senator, you'll recall during Senate Bill 1 in the last session, we addressed the provisional voting issue. And so solely by casting a provisional ballot, liability does not arise. Remember, the law wasn't clear before. So 2 years ago in 2021, we made the law clear that casting a provisional ballot in and of itself is not a sufficient act to catch someone. That's a great point, because that was a source of confusion during the last debate.
Well, in the Mason case that I know you're trying to address, I think I disagree with that analysis. And if you look at the Mason case, the voter actually did know that because she was a felon or a convicted felon, she couldn't vote. It was the clerk who directed her to vote a provisional ballot. So that means that a DA can go and have pretty much discretion of what provisional ballots the DA can select for prosecution?
No, so I want to be clear. The law has changed since the facts underlying the Mason case took place. And so today, that voting a provisional ballot does not trigger liability. We changed that 2 years ago, because that would be a concern, but that's not an issue today, and this amendment does not go to that.
I just have a lot of issues when you try to I just have a lot of issues when you start messing around with intent and what the law's rule is required to prove of a crime. And I certainly will not compare murder or burglary or assault with many of the criminal laws that we now have in all this outside the penal code, which people are not aware of. And they may know, as you put in your bill, know of a particular circumstances that's what you change it, knows of particular circumstances. If I know something that happened or that I don't live in the district, but I don't know it's a crime, you can convict me under Senate Bill 2.
Senator, I want to be clear, because you're right about the intent requirement. That's really central here. Now, the Dallas Court of Appeals for a long time has followed this same rule. If you know of the underlying facts that make you ineligible to vote and you still vote, you're liable. The Houston 14th Court of Appeals held the same thing. The Fort Worth Court of Appeals just last year held the same thing. It wasn't until last year that the Texas Court of Criminal Appeals changed the law. So this bill on the mens rea would restore the law to what it was before that Court of Criminal Appeals opinion, which went against over 100 years of Texas precedent.
Well, I disagree with your analysis. And if you look at many times, like in the Mason case, yes, she knew she had been convicted of a felon. She'd been released from prison. Sometimes there's a 90, 120 day before you issue the proper paperwork for our TDCJ. That means that she knew she was a felon, but she didn't know being a felon was a violation of the law. And that's the point. So what we're doing is a lot of innocent people are running the risk of making a mistake, an honest mistake, and end up being prosecuted under Senate Bill 2 the way it is written.
Well, Senator, I'll say this, and you may recall this. 2 years ago, when we were addressing this issue, we strengthened the law to make sure that in Texas, when you plead to a felony or when you're sentenced for a felony, the judge has to give you a specific admonishment and let you know this affects your voting rights. And I'm not an expert on this, but from what we understand, when you go through that process, when you are released, when you complete your term, you're given information by your parole officer. Here's where you stand now. Here's what you can do. Here's what you can't do. And so the information is there. And again, Senator, I will say this. If it's necessary to prove the actual intent that I knew that I was a felon and felons weren't supposed to vote, and I knew this was against the law, how could you ever prove that subjective intent? Short of a confession, there would never be a conviction for illegal voting.
No, I disagree with you. We give the courts a discretion to be able to interpret that situation. And you know very well, in many criminal cases, it's a matter of intent. Somebody can make an innocent mistake. Ignorance of the law, and that's what you have said,
yes, sir.
Is really not a way to be understand reality of what actually goes on in a criminal case. What is happening here, what is happening here, I'm sure you're familiar with the law of lenity.
The law, what's that?
Lenity.
Yes, sir.
Where the courts usually will give the defendant the benefit of the doubt on legislation or criminal laws that are not in the penal code or are not clear or ambiguous as to whether or not the defendant ought to be convicted. Would you agree with that?
I agree with that concept. Yes, sir. I would just say here, again, going back to 1888, the Court of Criminal Appeals held that knowledge that you had been convicted of a crime was enough to convict you for illegal voting. The Dallas Court of Appeals has followed that. The Houston 14th has followed that. The Fort Worth Court of Appeals has followed that. So, and again, you know the law better than I do, Senator. There's no question about that. But I think if we look at the cases, we'll find that what Senate Bill 2 seeks to do is restore the law to what it was before an errant Court of Criminal Appeals ruling. We are not changing the law. We are restoring the law to what it has been for over a century.
Well, I'll end by saying this, Senator Hughes, and that is that to commit a crime, the person needs to know that what that person is doing is a crime. And as you well know, the majority of our criminal laws here in the state of Texas are not in the penal code. They're all spread all over other statutes. So you are allowing people to come in not knowing that whatever it is they committed, it becomes a crime under election code. I mean, that's really unfair to a lot of voters. You may end up convicting a lot of innocent people who had no intention, no evil mind to commit a crime. I just tell you what the way I read this bill.
I understand, Senator. Thank you.
Thank you, Senator.
Senator Whitmire, for what purpose?
For the senator yield.
The senator yield?
Of course, I'll yield.
He yields.
Hughes, you ever think maybe the Court of Criminal Appeals knew what they were doing?
I didn't hear the first part of that. I'm sorry.
Did it ever occur to you that maybe the Court of Criminal Appeals knew what they were doing when they ruled, and you're trying to overturn it today? So maybe the court was right and maybe you're wrong. Did you ever consider that?
Senator, as you know, as lawyers, it's always awkward when we criticize the court. I believe the court got it wrong, and I know they went against 100 years of precedent when they did this.
Maybe for 100 years, we were wrong. When they looked at the facts of the case, fairness, and tried to arrive at justice.
I don't put any ill motives on them, of course. Nothing like that.
So have you ever watch the court ruling and run down to the state Senate to try to overturn a court decision before. I mean, you're doing it pretty quick. Would you not agree?
As you know, Senator, the legislature makes the laws and the courts apply the laws. And so when the courts get it wrong, the people acting through the legislature sometimes have to clean it up.
And I don't have, yeah, and sometimes they clean up our messes too. Would you not agree?
Oh, yes. Oh, yes. This bill does that too.
So I think what we're all striving to accomplish, certainly my colleagues who raised the 17-year-old voters, and I think there's other incidents. We're looking for what is fair, right, and not to wrongfully prosecute individuals for maybe human error. Would you not agree?
Yes, sir, that's right.
So the two instances that come to my mind is the gentleman that voted at TSU 2 years ago, thought he was eligible. So how are you trying to punish somebody with a felony that his mens rea thought that he was doing the right thing? So, and if you're familiar with that case, our local DA was not going to prosecute him because she looked at it as unintentional mens rea, that he didn't knowingly do something wrong. And they forum shopped and went to Montgomery County to prosecute him, indict him, and then ultimately it was dismissed. So what I'm really worried about, and I think many of my colleagues share my concern, the unintended consequences of what you're proposing today. I mean, people, in fact, getting back to a parolee, I would almost laugh if it wasn't so serious when you told the body that your parole officer describes to you and tells you what your rights are and your voting rights when you're taken off parole. You really don't believe they talk to them about that, do you?
Well, Senator, I'd say a couple of things. Again, if you plead to a felony, when you're sentenced for a felony, either through a trial or a plea bargain, the court must specifically admonish you about the loss of your voting rights.
You really think a defendant has that on his mind when that judge is admonishing him? Assuming you've never been a defendant, like...
I haven't yet.
Yeah, I understand, and I hope you never are.
Me too.
And I say that on behalf of all of us. But if you've ever been in court, the anxious, the nervous condition of a defendant standing there voting in the future is probably the last thing on his or her mind. Would you not agree? So for you to bring that up as one of the safeguards against your proposal date is just almost frivolous. That's not going to shock somebody into, oh, Lord, when I get out of prison in 12 years.
Well, Senator, everybody in the Senate 2 years ago voted for that provision, so I think it was a pretty good idea. It helps.
Of course it helps. It's better to believe they're going to admonish someone, and it's nice to hope that a parole officer will describe the conditions of parole and when you can become a legal voter. But Senator Hughes, that's not the safeguard against someone making an innocent mistake. And if they do, you're fixing to make them a felon. The case that you dealt with in the Court of Criminal Appeals, the poor lady in Fort Worth, her life has been ruined because she voted thinking that she was an eligible voter. In fact, she said in the court record in Fort Worth, I was just encouraged repeatedly, let's go vote, let's go vote. She did. It didn't impact that election, and we're all against voter fraud. But you really think she was fraudulently voting when all of her neighbors and friends signed her up and had her go vote? You know, not everyone is informed as you and I am.
All I know about that case is what's been published in the opinions and what I've read. And the defendant you're describing was not just a felon. She was convicted of fraud, federal tax fraud. And let me be clear.
He was
let me be clear.
Prisoner,
let me be clear.
Concerned.
Let me finish, Senator. Respectfully, let me finish. As Senator West would say, let me finish. Not only was she found guilty of defrauding her clients, but also defrauding the federal government and then charging her clients again on that. It's a pretty serious crime. It's not some little mistake or error. She was convicted of fraud, multiple counts in federal court.
I understand, and she was a poster person for against voter fraud, and you know, I don't know if you know the rest of the story. She lost her family, her job, was incarcerated. Do you think she knowingly voted fraudulently?
The jury believes she did, and
The Court of Criminal Appeals overturned that, did they not?
that's the opinion we're talking about. Yes, sir.
I know it. So I'm going back to the trial court, who was looking at her mens rea, and of course, in that jurisdiction, they hung her high. They ruined her life. She lost her kids. She'll be deported back to Mexico upon completion of this matter. Let's get to this so we can wrap it up. Define mens rea as you're using it in your statute. Is it intentional? Is it knowingly?
Intentionally.
Or what standard are you using?
Intentionally or knowingly is what the language is. I want to make sure I've got this right. I'll read it. The statute says a person commits an offense if the person knowingly or intentionally, and then it goes down the list, voting in multiple jurisdictions, voting when you're not registered, not eligible, keeping somebody else from voting, marking somebody else's ballot against their will. But the standard is knowingly or intentionally.
Most of the people that you and I represent would not know these legal terms. In fact, I've talked to a few attorneys on the floor, and there's debate among some of us as to what it really means. Tell me how this would affect an uninformed voter, the people that you and I represent that may not have familiarity with Senate Bill 2. They won't hear about today's vote. How do you protect just an uninformed voter that's been receiving literature, maybe a neighbor, a relative says, let's go vote, and in fact, they're not eligible. And they make a mistake, and you can call it whatever you want to in legal terms. How do you protect people that make a mistake and go vote?
Well, Senator, the standard, like with the other criminal statutes that we're all bound by, every one of us, is knowingly or intentionally. You're correct about that. It's
What about
knowingly or intentionally.
how about just not being educated to the law?
That would not be knowingly or intentionally. And as you know, in these cases, they go to before a jury. The case that we're talking about here, the jury heard the evidence, heard the testimony, and determined that the defendant was guilty. That's another thing we should think about. There's always going to be a jury behind these cases to look at the facts, the way the evidence. We're not there to hear the witnesses, but they are. Go ahead. I'm sorry.
Well, you have more confidence in some of the representation of people that would get caught up in this than I do. If you make an innocent mistake, you're not maybe considered innocent. I am. Uninformed.
Sir.
An uninformed voter gets prosecuted, like the gentleman did at TSU, Mr. Rogers, I believe is his name. He had no intention of voting illegally, but in fact, he was indicted. Court-appointed attorney. You know how you can get caught up in the criminal justice system over, in this instance, something that ultimately was found he was not intentionally doing wrong.
So he was.
So how do you protect
his case was dismissed then?
Yeah, after he's on the front page of every paper in the state. I just would ask you to consider the consequences, maybe the unintended consequences of your proposal. We're all against voter fraud. Would you not agree?
Of course.
In fact, we all as candidates try to protect the ballot process. We watch our opponents, we watch their supporters looking for fraudulent acts. But to come give it the gravity that you are today really frightens some of us who have worked with voters that just are not going to be as informed as perhaps you assume they are, such as someone coming off of parole, such as a 17-year-old high school student. So I understand you probably have the votes, but I'm just sounding an alarm that if we keep reaching for that system, enforce your voting laws, that you're going to, the net, if you keep throwing that net wide enough, you're going to catch some folks that are just uninformed, innocent voters, and they're going to find themselves in the criminal justice system. And I, in all due respect the Court of Criminal Appeals and think that that's why we have a Court of Criminal Appeals to review the trial court. And in this instance, would you not agree you're coming down here and putting yourself maybe better informed than the Criminal Court of Criminal Appeals?
Senator, of course, we always want to strike that balance, and we're all going to try to debate that and figure out the right place. I will say this, and I should have mentioned this, I know we're on suspension, but should the Senate see fit to suspend and the bill comes up, there will be an amendment which is going to help with folks who are maybe not sure about whether they're eligible based on their status as having been convicted of a crime. There's an amendment that may help with that. But I know we'll get to that in due course if the Senate sees fit to suspend.
You just made me think of something. Would this impact provisional voting at all?
No, sir. So
I mean, if I think I'm in this precinct, but I'm not sure, but they allow me to fill out a provisional ballot, what the world does that do to that process?
So last session this came up, and so the act of casting a provisional ballot in and of itself cannot give rise to liability under this statute. We clarified that last session.
Thank you.
Thank you, Senator.
Senator Johnson, for what purpose?
Questions of the author?
Senator Yield?
Of course, I'll yield.
Yields.
Thanks, Senator Hughes. Let's just start right where you left off. I want to be just crystal clear because the consequences we're talking about are essentially completely wrecking a person's life, and we don't want to take that lightly. I know you don't want to take that lightly. So this discussion about provisional ballots, are you telling me that if somebody has served their time in prison, is not yet eligible to vote, and they show up at an election, a polling place, and they cast a provisional ballot, that your statute here, if it passes, won't catch them?
Senator, 2 years ago, this came up in Senate Bill 1, and the casting a provisional ballot in and of itself is not enough to create liability. That's a change in the law from when we were here 2 years ago.
So
this amendment does not touch that, whatever.
I feel like we're sidestepping the real question. If that person, in the scenario I just described, casts a provisional ballot knowing that they've been to jail, and in the words of the statute, is aware that the person, that they know of a particular circumstance that makes them not eligible to vote, like just getting out of jail, and they cast a provisional ballot, have they violated your statute?
So the law says this in Section C, and I'm in 64.012, illegal voting, Section C. A person may not be convicted solely upon the fact that the person...
I'm sorry, Senator Hughes, where are you?
Section C of 64.012, I'm in the statute under illegal voting. The statute that's being amended if Senate Bill 2 passes. You want to
I'll just have to listen to you.
Sure.
Go ahead.
I promise.
I always do.
I'll read it right, I promise. 64.012, illegal voting. And Section C says, a person may not be convicted solely upon the fact that the person signed a provisional ballot affidavit under Section 63.011 unless corroborated by other evidence that the person knowingly committed the offense. So if there's something else in the record, something else the defendant says or does that shows they knew it, that's one thing. But the provisional ballot in and of itself is not sufficient to trigger liability. And I think that's important because that was a change from when we were here 2 years ago.
And
I hope that's helpful. Go ahead.
Sorry, Senator. Go ahead.
No, that's it.
I think it's not at all helpful or not even particularly interesting. All you've told me is that if he casts a provisional ballot, that alone won't get him or her in trouble. But the fact that they knew that they just did time in prison will get them in trouble. They're not exculpated as a result of the fact that the ballot they cast is provisional, correct?
Are you talking about if there's evidence that they're otherwise guilty for one of the other offenses in...
Specifically, otherwise guilty, to use a word that makes me shudder, of Section 1A1, that
well, may not be convicted. I'm sorry. Go ahead.
Well, never mind somebody from prison. Let's take somebody who moves counties and they forget to update their address. And they show up in their new county to vote, and the election official says, sorry, you're not on the rolls, but you can cast a provisional ballot consistent with federal law. Now, as I read your statute, they don't have to know that they're ineligible to vote. They have to knowingly or intentionally vote, not knowingly and intentionally break the law, but knowingly and intentionally vote while they know that they've moved. That's
so
it.
They would have to know that they were registered in a different county. Is that what you're describing?
They would have to know that they moved, and they would know also, I presume they would know that they didn't update their address.
Because the act of moving would not be a circumstance that makes them run afoul of the statute. It would be voting where you're not registered to vote.
That's right.
Thinking that folks should just vote in one place each election.
People who forgot to update their address and they show up to vote and they cast a provisional ballot.
Right.
Or the high school kid that Senator Menendez described, who, like my kids, forgot to read the stuff, and they thought they could just sign it at 17 years and 6 months, but you had to be 17 years and 10 months, and they show up to vote, and they say, "You're not on the rolls, honey, here, cast a provisional ballot." That kid's going down, isn't he?
Senator, that person did not knowingly or intentionally do any of those items.
Oh, they did. They knowingly and intentionally voted. That's all. Hang on. What word does knowingly and intentionally modify in the statute?
It modifies each of those elements.
No, it does not. It modifies. I'm sorry. I'm talking over you, and I should not answer, and then I'll disagree.
No, thank you. It says knowingly or intentionally. It's got a colon, and then there's 1, 2, 3, 4, 5, and it applies to each one of those.
And I'll read the statute verbatim with a little emphasis. A person commits an offense if the person knowingly or intentionally votes. And now we're all done with the modifier. And now we're all done with the modifier. It's they knowingly or intentionally vote. The rest of the sentence, in an election in which the person knows of a particular circumstance that makes the person not eligible. They don't have to know that they're not eligible.
They have to know that in your case, I'd have to know that I'm not registered to vote in the county I'm voting in.
That's right. They forgot.
That would be the circumstance.
Right.
Or know that I'm sorry, go ahead.
Or the kid would have to know that they were 17 years and 6 months when they signed that a pre-registration application. They would know their age, and they would be guilty under the statute, wouldn't they?
Well, Senator, we're not talking about changing anything that hasn't been the law for 100 years.
Oh, we are.
We haven't seen cases like this rolling up before now.
I'm seeing a change right here. I'm seeing underlined laws of a particular circumstance that makes the person eligible. I mean, I guess you're saying that I'm right.
I'm saying that's how the Court of Criminal Appeals interpreted the statute in 1888. That's how the Dallas Court of Appeals interpreted it, the Houston 14th, and the Fort Worth. I'm saying this Court of Criminal Appeals case was a departure from 100 years of Texas law. And so this change that you're describing is not a change. It's restoring what the law has been for at least 100 years.
So, Senator Hughes, is the motivation for your bill to pay homage to 100 years of Court of Appeals opinions, or are you trying to do something with the voting system?
Senator, the prosecutors have told us, in fact, one witness testified in favor of this bill, and he said, without this change, the only way one could ever prove illegal voting would be with a confession. He said, without this, there's no way they could ever prove such a case. I don't think either one of us wants to make it that difficult to prove a pretty serious offense.
Oh, I think many crimes are proven with circumstantial evidence, and wrongful intent is generally proven through circumstantial evidence. For example, they show up in a voting location, and the people at that voting location tell them, "You are ineligible to vote at this location." They have a conversation, and the voter says, "Oh, that's right, I'm registered in another place, but I'm going to vote here." Or they go to 3 different locations and they vote. Or any number of circumstances. So let's take the prisoner example. They're
What
out
should
of there.
be the offense level for the person you just described?
I'm sorry?
What should be the penalty range for the person you just described who's
Well, we already
trying to
have
cheat?
one in there. It's $4,000 and a year in jail, which seems pretty discouraging. Now, I will notice that when we lowered the penalty here from second-degree felony to a misdemeanor, we did not see a surge in attempts to vote fraudulently, did we?
We have no idea. It takes cases a while to move through the course. I haven't seen any statistics one way or the other. If you do, please share them with us. I don't know.
Well, we've had this discussion on the subject of what the point of this bill is and whether we're just paying homage to a bunch of 100 years of bad appellate court decisions, or we don't like the Court of Criminal Appeals, or really we're trying to make sure, you're trying to do something, you're trying to stop fraudulent voting, which we don't know exists. In fact, we don't have any evidence of anything this statute would hamper other than perhaps voting. So I'll move on. I have a question for you. Is there any discretion in the prosecution of offenses under this bill?
Yes.
Whose discretion is that?
Whatever rules apply to any other criminal statute. As you know, there's a big discussion about prosecutors who refuse wholesale to prosecute certain cases. But as far as the law, as I understand it, a prosecutor exercises discretion on what cases to bring, what charges to pursue, and also what level of penalty to seek. They're not required to seek the full range of punishment. I hope that answers your question. I'm not sure if I understand.
I think very specifically, what office has the authority to prosecute violations of this statute if it passes?
Oh, so the district attorney's office, county attorney's office, depending on the jurisdiction in which you live. Yes, I understand it.
And what might persuade a prosecutor to abandon the prosecution of a statute like this, even if the person knows that of a particular circumstance that makes them not eligible to vote.
What might cause him to decide not to pursue?
Yeah.
I've never been a prosecutor, from what I understand. They look at the strength of the case. They look at what the odds they think are of a conviction. They look at other cases that they have to pursue with their limited resources, and I think they're supposed to make the decision along those lines. But if you know something I don't know, please help me out.
No, I'm just a little concerned that we've got district attorneys throughout the state of Texas that might have different motivations. Some might want to prosecute some people and not others. Might be based on anything. Could be a partisan ideology, it could be race, it could be all sorts of things. We've got this, because there's no element of criminal intent, the element of intent just winds up with the prosecutor and not in the law.
Knowingly or intentionally. Senator,
Knowingly
if I break into your house and take your stuff, I don't have to know that's in the penal code. If I knowingly or intentionally break in your house, take your stuff, I can and should be prosecuted. I'm not going to do that, of course. But that's the idea. That's the intent we're talking about.
But if you broke into my house, I can presume you've had a wrongful intent. And if someone casts a vote, I don't have that same presumption.
It depends on the circumstances. That's why the particular stances are referenced in the amendment or in the bill that would amend the statute.
The circumstances is merely that you knew of something that made you ineligible to vote. The circumstances don't show, and I guess you're presuming a wrongful intent in that case. The burglar, I'm pretty sure they've got a wrongful intent. The voter?
Easier to prove. Easier to prove.
Much less inclined to believe that. Okay, you're aware of House Joint Resolution 123 from last session?
Well, would you refresh my memory?
Certainly. Last legislative session, the Texas House of Representatives passed a resolution, and it passed 119-4. And the text of that resolution read, quote, cases of genuine mistake where the person votes or attempts to vote under the honest belief that the person is eligible to vote should not establish the required knowledge of one's own ineligibility. And in such cases, the ineligible person's vote should not be allowed, and any vote erroneously cast by an ineligible person should not be counted, but a person should not be criminally incarcerated for making an innocent mistake. Passed 119-4, and it directly contravenes your proposed bill here.
Well, Senator, I don't believe it does, and I don't recall if that came over to the Senate and it was taken up or what the circumstances was or what the debate was about in the House. But again, we're talking about restoring a precedent that's been the law in Texas for decades, applying it like we do to other criminal statutes. What Senate Bill 2 seeks to do is to restore what the law has been, the predictable law that folks rely on which they order their conduct. It's not some radical departure.
We disagree about the reading, how we read your bill. I think it's menacing, and I think it will make criminals out of people who are not criminals. I hope that's not your intention, but I urge you to re-examine the language. I think we need some grammatical construction discussions. Maybe we'll have them later, but I'll be voting against your bill because it makes me very, very nervous.
Thank you, Senator.
Thank you, Senator Johnson. Senator Hoffman, for what purpose?
Permission to question the author?
Do you yield?
Of course, I'll yield.
Senator Hughes, there's been a lot of discussion already this afternoon. I'm sure there'll be more. But I thought it might be a good idea just to slow down a little bit and just remember the basic tenets of criminal prosecution and criminal law, what happens in a criminal court. And we all need to think about that. Though this bill does create a criminal penalty, all the laws that always apply in a criminal courtroom, all the defendant's rights, their presumption of innocence, the requirement that the prosecutor prove each and every element beyond a reasonable doubt, all apply in your bill. Am I correct?
Senator, that's right. Thank you for that. And that beyond a reasonable doubt, isn't that the highest level of proof we require in America?
Absolutely. And it requires a unanimous verdict by a jury. So all 12 people who would be selected from the community in many of the counties now. I know in Harris County, which is one of the largest county, the jurors, the pool is randomly selected. So you have a very broad, diverse group of the community that is present. to sit in judgment of a person who is accused of this offense, correct?
That's right, Senator.
Right. So again, we need to slow down and think about the situation where this bill would come into effect. Now, your bill requires, there's been a lot of discussion of mens rea, and your bill requires either an intentional or unknowingly state of mind. Is that correct?
Yes, Senator, that's right.
Okay. And just bear with me, because I think it's important that the members listen to what's required for something to be proven intentionally. And it means with respect to the nature of his conduct or to a result of his conduct, when it is his, or her of course, conscious, objective, or desire to engage in the conduct or cause the result. Correct?
That's right,
And
Senator.
that's a little higher than knowingly, but it's included in your mens rea. But knowingly also is when a person acts with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct, when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Again, this is something that the prosecutor would have to prove, whether it be circumstantially, Senator Johnson, or actual documentation or whatever methods or testimonial evidence. There still has to be evidence proven beyond a reasonable doubt that this mens rea, one or the other, exists. Correct?
That's right, Senator.
Okay. Then looking at your bill even further, it says that a person who commits an offense, if the person knowingly or intentionally votes or attempts to vote in an election in which the person knows of a particular circumstance that makes the person not eligible to vote. I promise you, as a former prosecutor, a prosecutor will look at that and realize that they have to prove beyond a reasonable doubt that the person knows that this circumstances exist. This is what the law says. It's going to be an element of the crime. And if it's not proved beyond a reasonable doubt, I guarantee you the person is going to be found not guilty or never indicted by a grand jury. More likely, that would be the likely scenario. Or prosecution declined by a district attorney because it's impossible to prove. So that's the point I wanted to make, and wanted to make certain that as you structured your bill, that this was your intent, that all the rules apply. And I would say, looking at this, that it's going to be tough to prosecute these cases. I know there's concern, and I certainly respect the concerns of the members. No one wants a person who is completely innocent to be accused of anything at all. But I think that there are sufficient safeguards built into the system and built into your bill that will create sufficient safeguards. So thank you for bringing this bill forward, and I look forward to voting for it.
Senator Huffman, thank you for that. And I stand to be corrected, but if I'm not mistaken, you're the only one on this floor who's served as a prosecutor and a judge. And
I think that's correct.
Thank you for sharing that with us. That helps me a lot.
Yeah, well, we get to talking, and sometimes we just forget that all the other rules of law still apply. They all apply to these cases. Thank you.
Thank you, Senator.
Senator Alvarado, what purpose?
To ask the author a few questions.
Do you yield?
Of course, I'll yield.
Thank you. Senator Hughes, it seems like just yesterday we were here debating Senate Bill 1 for quite a while, or at least I was.
It does.
A couple of scenarios have been brought to your attention. So let's talk about, the fact that we have so many new people moving to our state. We have people moving from all over. Let's say we have a new Texan. Say his name is Jim. I did that for you. Let's say Jim submits his voter registration application 29 days before. He's not aware of the 30-day rule. He goes to vote, they allow him to fill out a provisional ballot, okay? So how would your bill affect Jim? Would Jim be facing 2 to 20?
Senator, it doesn't sound like he would be voting or attempting to vote in an election in which he knew of the circumstance that makes him ineligible, as I understand the facts you presented. And also, as Senator Huffman said, a prosecutor would have to decide whether to prosecute. A jury, hearing all the evidence, would have to convict, and then a judge would have to sentence. But I believe that the gentleman you described would be fine under the statute.
Okay, I'm going to have to look at that a little closer, because that's not the way I'm reading it. And I think that's why so many of us have stood up and come up with other scenarios, whether it's the person that's out of prison or the 17-year-old. So we can circle back to that. So speaking of the provisional ballots, there is a part, and I'm sure you know this, in the election code that allows a voter to cast a provisional ballot. And were you aware that in 2016, 44,000 provisional ballots were rejected in Texas? And that was because people were not registered in the relevant precinct, including citizens who had moved, went to the wrong polling location, or registered too late. 44,000 ballots of that.
I knew there were quite a few. I didn't know the exact number, but of course I believe you. If that's the number,
Okay.
I'm sure that's right.
So why would people like that I just described, who honestly believe that they were eligible when they cast that provisional ballot, be criminally prosecuted and now be facing 2 to 20?
Well, Senator, we're not aware of that any of those people were, because under the law as it was at the time, which this bill seeks to restore, casting a provisional ballot in and of itself is not sufficient to give rise to a criminal prosecution under the statute.
Okay, let me go further. Earlier you mentioned, and I believe in your committee meeting, you mentioned 50 years. Can you restate that again?
You bet. I think I may have said this has been a penalty for a felony for almost 50 years. Let me be precise. I believe it was 1975 when the penal code was recodified. It's been a felony ever since 1975, and then in 2021, with that one amendment at the 11th hour over in the House, it was changed. But that's where I got I hope I said almost 50 years. I meant to say almost 50 years. 1975 is the year I'm looking for.
Okay, well, just looking back in legislative records and research, illegal voting first became a second-degree felony in 2011.
I think it was a third-degree felony before that.
Okay, and in Senate Bill 1, I think you referenced this, or someone did, of 2021, it made it a Class A misdemeanor.
Yes, that's right. That's exactly right.
So illegal voting was only a second-degree felony for a total of 10 years?
It was a felony from 1975 until 2011, or whatever, forgive me, whatever the year was, went from third degree to second degree, but a felony of some classification since 1975.
Okay. I think Senator Hinojosa brought up a point that that your bill would allow criminal prosecutions in circumstances where the voter was unaware of the law. Texas law contains over 1,700 criminal defenses, but only approximately 300 of them are found in the penal code. So why do you believe it's reasonable to expect that Texans know the roughly 1,400 criminal offenses outside of the penal code, including those in the election code?
Well, this bill pertains only to one of those offenses, and that's for illegal voting, and that's for voting or attempting to vote when one is not eligible, or voting more than once, or voting a ballot belonging to another person. Items like that are wrong. People know that they're wrong, and that's why the law is handled like it is. I'm sure there are some random criminal offenses that, like you're describing, that might be more unusual, but it shouldn't surprise anyone that folks who are not citizens don't get to vote. That things like that that are addressed in this bill are in a different category. It's like breaking into somebody's house and taking their stuff. You don't have to know that's against the law to know that it's wrong and to be held accountable for it.
Senator Hughes, I will respectfully be voting against your bill. There is a reason why Texas is known for having some of the strictest laws when it comes to voting, and it's labeled as one of the hardest, if not the top most difficult state to vote in.
Thank you, Senator.
Senator Miles, Senator Miles on the floor. Sorry. Senator Eckhart, you're recognized. What purpose?
To ask questions of the officer.
Do you yield?
Of course I'll yield.
Thank you so much, Senator Hughes. And also thank you, Senator Huffman, for walking us through the criminal procedure. I agree with Senator Huffman that the law, as it's currently written, even without this bill, is a difficult law under which to prosecute someone. So I would like to look at it at the specific additions you make and how they affect the current state of the law. So much has been made of the mens rea. There are 4 different levels of criminal culpability, correct?
That sounds right, and I'll defer to you, but that sounds right.
So intentional, knowingly, negligently, recklessly.
I believe that's right. I'm sure that's right.
So the bill, the law already states intentional and knowing.
Yes, that's right.
What adds to the current state of the law the phrase of a particular circumstance?
The question is whether one has to know that the act is the very issue we just described with Senator Johnson. Forgive me for going back to this, and I'm not prone to burglary, but if I break into your home and I take your property, I don't have to know that it's in the penal code that you can't do that. If I knowingly or intentionally break into your home and take your property, then I can be tried, I can be convicted for burglary. That's the idea. So the defendant does not have to know this is in the penal code. I'm not supposed to do this. If the defendant knowingly or intentionally commits those acts, then they are responsible and they can be held liable under the statute. So that's the idea. And again, it's restoring what the law was for over 100 years until last year's ruling by the Court of Criminal Appeals.
You continue to use the simile of a home invasion. Another second-degree felony is an aggravated assault. In both of those instances, one does not need to, those are both victim crimes, where just the fact of breaking in is circumstantial evidence of criminal intent, whereas the fact of showing up at the polls to vote is not circumstantial evidence of criminal intent. So it's an inapt simile.
Well, showing up to the polls in and of itself under Senate Bill 2, of course, would not give rise to liability. It requires more than that, wouldn't you say?
It requires intentional or knowingly in the current law. I'm trying to divine from you why even add the verbiage of a particular circumstance. That actually broadens the people who would be at risk of prosecution.
I see what you're asking now, and the Court of Criminal Appeals ruling and the Fort Worth Court of Appeals ruling last year are helpful on this. They go back and look at all the cases, and again, going back at least to 1888, having knowledge of the facts making one ineligible are sufficient for one to be held accountable for illegal voting. And that's been applied by the Dallas Court of Appeals, by the Houston 14th, and by the Fort Worth Court of Appeals. So that's been a law for a long time. The reason we are seeking this amendment to the statute is because of a Court of Criminal Appeals ruling last year that changed all that. So I understand your question now. I apologize.
Do you agree with me that adding the language of a particular circumstance broadens the fact patterns under which a person could be prosecuted?
I don't, as I walk through the question with you, I don't believe it affects the fact patterns. I do believe it makes it not impossible to prove short of a confession.
I did hear you make that remark to Senator Johnson. Of course, nothing in this law as it currently is written or as you propose requires a person to confess before they can be prosecuted, correct?
As a practical matter, the prosecutor that testified before the Senate State Affairs Committee on this bill said that under that Court of Criminal Appeals ruling, they didn't know how they would be able to get a conviction in one of these crimes short of a confession. They said we need the language in Senate Bill 2.
So you're aware of the definition of the negligence standard for criminal culpability, for criminal intent, correct?
Generally, yes. But whatever you say it is, I believe you. I couldn't quote it. But
that you're aware of the circumstances, but you go ahead anyway.
Not unlike civil negligence, but a little different as applied here. Yes, ma'am. I believe that's right.
So would you agree that by adding the words of a particular circumstance, you have reduced the mens rea to a negligence standard?
Well, no, I don't believe that's the case, because one still must knowingly or intentionally vote or attempt to vote knowing of that circumstance that makes one illegal. The fact that I'm not a citizen, or the fact that I'm a felon and I've not completed my terms, my voting rights have not been restored, that's the idea.
But you've already heard several of our colleagues tick through a number of circumstances that a voter could be aware of without the voter being certain that that circumstance has made them ineligible.
Well, in some of the hypotheticals that have come up, it sounded to me like they would not be subject to liability under the statute. I confess I don't remember every single one, but they were kind of a mixed bag, as I recall.
I agree. So there's a number of circumstances in which a voter could be aware that it might make them ineligible. They're not certain they're ineligible. So they go to the polls to cast a provisional ballot because they want to participate in their democracy, correct?
Are you asking what their knowledge is, or?
I'm saying that there are a number of circumstances. We heard about the change of address. You live in Williamson County, but you moved down to Travis County to go to the University of Texas. So the vote comes up, you have you've registered in Travis County, but you're not sure if your registration is taken or not. So you go to the Flawn Academic Center to cast your ballot. The folks who are running the election say, we don't see you on the voter rolls. You say, hey, I just moved down here from Williamson County. I changed my registration. I'll vote a provisional ballot. I know of the circumstance that may make me ineligible to vote in Travis County, but I'm not sure if it applies to me. So I will vote that provisional ballot. So that person knows of a circumstance that might make them ineligible.
I think I see where you're going, Senator, and I think I can answer your question.
And we'll call him Jim.
In the situation you described, it's not that they must know of a circumstance that may make them ineligible or that might make them ineligible. They must know of a circumstance that makes them ineligible. And forgive me for missing that distinction you were drawing. You're correct. If we said might make, may make, that would be lowering the standard of proof. And I see what you're saying now. We're not doing that. We don't want to do that.
And I concede your language says of a particular circumstance that makes the person not eligible to vote. So Jim knows that this circumstance of moving from Williamson to Travis might make him ineligible in Travis. So he instead of voting in Travis, he goes to Williamson County and says, I've moved, but I'm still registered in Williamson County. I've changed my driver's license to my current address, but I want to vote. So Jim votes in Williamson County.
Go ahead.
Jim now guilty of a second-degree felony.
So in your hypothetical, he knows he's registered in County X, but then he votes in County Y, or he's not sure his registration
He
went through.
knows that he has moved from Williamson County and he has changed his driver's license address to Travis County, where he now lives. But he didn't re-register in Travis because he really wanted to vote in this election. So he goes and he votes in his old county of Williamson County.
He votes in the county where he was registered, or the one he moved to? I want to make sure I'm tracking. I'm sorry. I want to make
The
sure.
one where he's registered, not the one where he has moved to and changed his driver's license.
Okay, I see what you mean. I see what you mean. So if he's registered to vote there and not somewhere else.
But he's been living in Travis County for a year.
Well, Senator, it sounds like you're describing someone who knows they don't live there anymore and they're trying to vote there. That sounds like a problem to me. Now, the prosecutor would decide what to do. The jury would decide if it got that far. That sounds like a problem to me. That sounds like something that the public policy of Texas would not be in favor of, right? I vote, where I live. And again, I'm just based on your hypothetical, and I hope I'm keeping up with you.
Oh, no, that's totally the hypothetical. So student Jim, who's moved from one county to another, knows that he's moved, knows that he was supposed to change his registration, but he voted in Williamson County.
But Senator, if he didn't register to vote in the new county, then there's no way he's on the voter rolls. There's no way he's
still on the voter rolls in Williamson County. He votes in the statewide election. He really wanted to vote in that statewide election. He didn't figure it made much difference whether he lived in Williamson or Travis. So he voted in that statewide election in his old county where he doesn't live anymore. He knew of a circumstance. He knew he'd been living in Travis County for over a year, and he changed his driver's license. But now he is subject to a state jail felony.
I probably missed the student part, and I'm sorry. As you know, one can move somewhere for school, and their permanent residence is still where they lived before they came for school. And so, as you know, residents in a case like that, they can vote in one place or other, but not both. We don't want them voting in both. However they vote, right?
Such a good point.
I hope I'm answering the question. Is that what you're talking about?
Oh, yeah. So let's say Jim is no longer a student, but same fact pattern. He's moved one county over. And he knows he's moved one county over. He hasn't bothered to change his voter registration. He just goes back to his mom's house and votes. So he knew of the circumstance. So now he is subject to prosecution for a state jail felony because he voted in a statewide election one county over.
I believe in that case, under Texas law, and again, you know the law better than I do, but I believe that would still be his permanent residence. If he hasn't moved his voter registration, if he hasn't made permanent moves like that, again, I know hypotheticals are hypotheticals, but it sounds to me like if you were his lawyer, I think you would probably argue that his permanent residence was in Williamson County. I'm not telling you what to do, but I think that would be his defense.
If I'm his lawyer, certainly I'm going to argue that. But in truth, his permanent residence is Travis County. He's been living here for more than a year. Changed his driver's license.
Well, there's nothing magic about a year or driver license, as you know.
And I'm not saying that Jim accidentally voted where he wasn't supposed to. He knew he was registered, should have been registered at his permanent residence. But he figured, no biggie. I'll just go back to my home county, which is one county over, which was wrong, and under the current law would be a Class A misdemeanor, but under your provision, it goes from a Class A misdemeanor to a state jail felony, correct?
So the difference would be 1 year in jail for the Class A, and then a minimum of 2 years for the low-level felony, up to 10, depending on the circumstances.
Oh, you're right. It's a second degree. What Jim did just then was a second-degree felony, not a state jail felony, right?
I believe it's second degree. Yes, ma'am.
Wow. So, yeah, poor Jim. He's now in prison, potentially, with people who are, aggravated assaulters and whatnot, because he went to his mama's house, his mama's home county, to vote for a statewide.
It's going to depend on the facts of the case, and there's going to be a prosecutor and a jury and a judge involved in a case like that, if it ever got that far.
Also, you know, every time we have an election, the election results go to the commissioner's court for verification, for certification, right?
Yes, like the canvassing process, is it? Yes, and you're the county government expert, but I believe that's right.
And so in that canvassing, the county clerks often find people who have voted twice. And it is 99.999999% of the time, they did a mail-in ballot, forgot about it, and then showed up on election day or early voting and voted again. So those folks are subject, if they knew that they, of a circumstance, well, not even a circumstance, because in this case they voted twice, so it's not under that provision. They voted twice, knowingly or intentionally voted twice. So they knew they put in a mail-in ballot, but they didn't get any receipt and have no proof that their mail-in ballot was accepted. So they go to the polls and they want to vote to make sure. And the clerk says you can do a provisional ballot. They know of that circumstance. They know that they're about to vote twice. That person, if they succeed and their vote is accepted, their provisional ballot is accepted and gets knocked out by the commissioner's court in the certification, it's a second-degree felony, correct?
From 1975, that was a felony. In 2021, it became a Class A misdemeanor. Senate Bill 2 would take it back to a felony. So if there was not a rush on those convictions before, it's unlikely to change now. But in the circumstance you described, I can't imagine a prosecution of a case like that. But again, we're just restoring the law to what it was for almost 50 years.
And you think that should be a second-degree felony?
That's a very good point. First-degree felonies can be things like illegal barter expenditure, tampering with a consumer product. If there's enough money involved, electronic data tampering, theft of telecommunication services. Those are first-degree felonies. If you want to talk about second-degree felonies, those can be any number of things, some which sound pretty serious. When we think about illegal voting, I think we all agree that that's a big deal, that vote, that franchise is precious and ought to be treated that way, which is why it was a felony for almost 50 years until 2021.
So to be clear, Jim, who turned in a mail-in ballot, doesn't see any evidence that the mail-in ballot was accepted. Jim's over 65 and disabled. So Jim gets himself down to an early voting location, says, I don't have any evidence of having voted and I'm super concerned that my vote get counted. I want to put in a provisional ballot. Yes, I turned in a mail-in ballot. Yes, I am voting a second time, but I'm going to rely on you, county clerk, to figure it out. Jim should be liable for prosecution for a second-degree felony.
Senator, I don't think that you or I believe any prosecutor would prosecute that voter, whether it was a Class A misdemeanor or a Class C misdemeanor or a first-degree felony, on the fact pattern you gave.
Do you think increasing the penalty, also under the current law, it's a Class A misdemeanor whether the ballot is accepted or whether the ballot was merely attempted, correct?
Voter attempted vote, yes ma'am, that's right.
So under current law, it's a Class A whether accepted or attempted.
All things equal, that's correct. Attempt is enough, just like with many other crimes.
So you intend to increase the penalty class to a second-degree felony for an accepted ballot and a state jail felony for an attempted ballot. And do you believe that that will deter voters?
Well, as we discussed earlier, and this sort of came up, when a prosecutor has to determine where to invest resources, what cases to pursue, those cases with a higher offense level, I'm told, tend to get more attention. But for almost 50 years, this offense we're discussing was a felony. For less than 2 years, it's been a Class A misdemeanor, the highest level misdemeanor. Senate Bill 2 would put it back to a felony where it was since 1975.
Do you believe that increasing the penalty class, I'm going to ask the question again, do you believe that increasing the penalty class will deter voters?
You mean voters who are attempting to vote illegally, or deter voters who are exercising the franchise through the normal process? What voters are you talking about? The goal is to deter illegal votes. Let me be very clear. Yes, I want to deter illegal votes, no matter who they're for or against.
I'm going to stop my questioning here, but just say I think that this is not, I've heard many of my colleagues talk about prosecution of innocent mistakes. I think that we have now moved into a territory where we're prosecuting people for well-intentioned mistakes. Well-intentioned mistake of risking voting. Voting has now become a risk, and that I don't believe is what we want to be doing here in a democracy.
Thank you, Senator.
Senator Betancourt, for what purpose?
Ask questions of the author.
Senator Hughes, do you yield?
Of course I'll yield.
Senator Betancourt, you're recognized.
Thank you, Mr. President. There's some things I think we need to talk about and make sure that we're not leaving information out there that is not part of your bill. And let's go over provisional ballots one last time, if we could. And I think it's because it's very important to understand that in the bill as written, provisional ballots are not a cause. They're specifically exempted from SB2. Is that not the case, Senator Hughes?
Senator, if one casts a provisional ballot and that's the only thing, there's no other evidence, no corroborating evidence that they knowingly or intentionally violated the statute, then that provisional ballot has no effect. It cannot be the basis for liability. That's correct.
Right, and that's very logical because as somebody that used to count provisional ballots, okay, these are cases where voters come in, they're not sure if they're on the rolls. In fact, the election judge can't figure it out. In some cases, Election Central can't figure it out. And so they have to, Senator Eckhart actually have to go check them out. That's the whole thing about provisional ballots. And it's important to understand that when you're in a provisional ballot environment, the whole purpose of it is to try to see whether or not the voter's intent to vote can be honored through the system of registration, and also for the verification and cross-check it. Now, Senator Eckhart also brought up something called, it's actually not called voted twice. There's a form that all voter registrars fill out. It's called allegedly voted twice. And I'll use the term allegedly very importantly, because that's something where, again, the election officials have to engage in a review of whether or not the voter actually voted twice. And as Senator Eckhart, knows, those come back to be almost, assuredly, generally not a case for prosecution. Now, and again, Senator Hughes, there's no intent, no way provisional ballots are going to come in. When we're going through a due process scenario like Senator Huffman went through, you have to look at events. You can't just say somebody voted twice. Trust me, I've done the investigations on these before, and they can be rather torturous because there's a whole variety of errors, not just voter errors, it's system errors, it's registration errors, you name it. But you're not going to come back and put provisional ballots in or target people that are trying to use provisional voting.
That was a good change to the law last time, and I think it makes a difference.
Now, from an overarching perspective, I just want to make a comment. We hear on the floor and outside the building too that Texas is a terrible place to vote, worst election laws in the country, you can't vote, et cetera. And I just want to point out to the members that in 2016, when we had a presidential election, we had 8,969,000 and change of votes. that voted. It popped all the way up to 11,315,000 in 2022. Now, my Aggie math tells me that somewhere in the neighborhood of 2,350,000 more votes. Now, is it reasonable to say, Senator Hughes, that when you see a growth in the vote in the presidential election, and we're up to, for the first time, I think in modern Texas history, many, many decades, I have to go back, that's a 66.67% turnout.
It's encouraging, and hopefully, as people know they can rely on the system, no matter how they vote, no matter for whom they vote, if they know they can rely on the system, it's going to be fair, it's going to be accurate, it's going to be secure, they're more likely to participate. We've seen that happen in the past.
Right, and what happens that, you know, that drives voter turnout, the number one factor is competitive elections, okay? You know, elections of interest, people wanting to come to the polls to vote because they are passionately swayed, you know, for a candidate or sometimes against. But when you see that type of turnout, that is astonishingly high, 66.67% by Texas standards. And because it is Texas, it produced a whopping 11,315,000 votes. I think the point here is it's in the last 4 election cycles, Texas has averaged over 8 million votes. If there was anything in these bills that was somehow a giant preventer, I think we'd all know about it. And clearly, you know, your recognition of taking provisional ballots out of your bill at this point in time is a recognition of the obvious that we've had a tremendous increase in the presidential election in voting in Texas, and people have used the provisional ballots successfully. And that really goes back to the Help America Vote Act, where it's set up nationally. So I just want to comment on those 3 points for you. And my question to you is that there is no fact or supposition of fact that this is a prevention of voting for someone that is not in, that's in this regular flow of voting.
You explained the situation quite well, Senator. That's what we're trying to do, is make sure the system is fair and predictable and consistent. And really, we're just restoring the law to what it has been for a long time.
Right. Well, thank you very much. I'm happy to have signed on.
Senator Miles, for what purpose?
Would the author yield?
Senator Hughes, do you yield?
Of course I'll yield.
Senator Miles, you are recognized.
Thank you, Mr. President. Senator Hughes, you know, 1979, Blind Ray Charles made a hit song called Here We Go Again. And it was later duplicated by many artists after that. So we're going to try to run this record back and make it a hit again.
You're not too young to remember that, but we've read about it, though. Yeah.
You know, y'all have been talking about a fictitious person by the name of Mike. But I wanted to ask you, Senator, do you remember a gentleman that I introduced you to in 2021 in the 87th legislative session by the name of Herbert Rogers?
I believe so.
What do you remember about him?
I read a little bit about his case. We just kind of met in
We discussed
passing.
it. Remember I told you he was a constituent, he was a personal friend, he was from the neighborhood, we grew up together.
Yes, sir.
And he was in the literal sense a homeboy, what we call a real homeboy.
Yes, sir.
Herbert was a man that was convicted of a felony in 1996. This was his second felony, and he was released in 2004. On parole, he was arrested after he voted in the 2020, if you remember, primary. You remember that?
That sounds familiar. I'm sure that's right.
He stood in line for nearly over 6 hours at Texas Southern University to cast a ballot. And just like millions of other Americans, Rogers knew he was released from prison 16 years earlier. As a result, he believed, and he had believed, and he had served his time that he could vote. Because he had served his time that he could vote. Do you remember that? We discussed all that?
I remember this discussion. Yes, sir.
What he may not have known is that he had just 3 months until his discharge that would have allowed him to vote properly. Mr. Rogers knew he was a felony. a felon. And with your bill, the simple fact that Mr. Rogers knew in his past that he was a felon, he knew it. He was a felon. He would be convicted of another felony. You remember those conversations?
I remember the discussion. I read some about this in the paper also. Yes, sir.
So this is a person. This is not a fictitious, figure. This is real. So with your bill, are you saying to Mr. Purvis Rogers that we're going to criminalize and prosecute individuals like Purvis Rogers for the lack of information?
Well, I'll say this. There's an amendment coming, if we get to that I think was going to help a whole lot in terms of letting people know. But to be clear, one, the knowledge required is that I'm a felon and I've not yet had my voting rights restored. Different states do that different ways. But in Texas, once your voting rights are restored, of course you can vote. You should vote, and we encourage people to vote.
So Senator Hughes, this is the second time I've heard of this amendment that's coming. Where is it coming and what does it say?
The amendment's going to require signage at polling places to make folks realize that if they've got a felony conviction, they should take notice, just to let people know so they don't get surprised. It actually came up at the hearing on this bill. One of the witnesses suggested maybe put up signs so people don't get blindsided, to make sure people understand. That's the idea about the amendment.
So
it came from a witness.
Request signage that says, if you're a felon, remember you can't vote?
No, sir. Just let's get to I don't have it in front of me. We can get to, let's talk about it when we get the amendment. Just letting people know that your voting rights may be affected.
So you want me to vote on the come? In betting terms, you want us to vote on the come.
We won't be passing the bill until the amendment comes up. I won't ask you to vote for the bill until the amendment comes up.
Okay. Senator Hughes, I just want to simply say to you, what you're asking us is to charge a man, in this case, Purvis Rogers, as I said, a true homeboy, somebody that I know, a constituent, that thought he had paid his debt to society in serving his 16 years and was simply trying to do as millions of other Americans were doing, and was casting a vote. We're going to charge him with in your bill, we're going to charge that guy with a state jail felony for just trying to cast a vote, not knowing. I'm almost in the same opinion of all of my other colleagues. It's almost, the bill is just, it's a terrible bill. As I said to you in 2021, it's a terrible bill. It's going to cause lots of problems. And in the spirit of Purvis Rogers, a constituent of mine, whose charges were later dismissed of voters fraud.
That's good.
I think you should know that.
It sounds like that.
In his spirit, I'll be voting no on your bill.
No, I understand, Senator.
And the amendment.
Thank you.
Senator Gutierrez, for what purpose?
Thank you, Mr. President. Just for a few questions, if I may.
Senator Hughes, do you yield?
Of course I'll yield.
Senator Gutierrez, you are recognized.
Thank you, Mr. President. Senator, thank you for your time. So Purvis Rogers' case was actually dismissed because there was a Court of Appeals opinion that said, I think it might have been in the Supreme Court opinion, that said that the Attorney General could not proceed and prosecute election crimes. Is that correct? After they went to Montgomery County. Thank you. Case was processed, proceeded from Harris County. It was filed in Montgomery County. It was forum shopped. Okay? That case was dismissed, as you suggest. Is that correct?
If that's what you say, I believe you. I believe you and Senator Miles. I don't have the file, but I believe you. I'm sure that's right.
It was dismissed after a higher court said that the Attorney General could not prosecute election crimes. Is that not correct?
If that's what you say, I'm sure that's right. I don't have it in front of me. I have no reason to doubt you. If Senator Miles agrees, I'm sure that's right.
You said something earlier. You said the legislature makes the laws and courts interpret the laws. Did I get that right?
I should have said apply, but apply, interpret. Yes, sir. That's what I believe.
Okay. The legislature.
They call balls and strikes.
Fair enough. The legislature makes the laws, and our courts apply the laws. Is not what you're saying now?
Sure. But interpret is fine. I wasn't trying to split hairs. I just don't remember exactly what I said.
Okay. Fair enough. The legislature thought it best, and you kindly said earlier that we reduce this to a misdemeanor at after 100 years of it being a felony or 50 years of it being a felony. The legislature made this into a misdemeanor. Are you saying that the Republicans that held strong on that particular amendment in the House that got together with Democrats on that particular amendment, that they didn't know what they were doing when they reduced it to a misdemeanor?
Senator, I think you may be referring to the Kane Amendment. This was the Allison Amendment, and it was accepted by the author without a vote, without objection.
Okay, still the Allison Amendment.
Yes, so there was no debate, there was no discussion of it.
But it was debated in this body, and it was debated at times in the House.
No,
because
sir.
Crystal Mason's case was ripe at the time. She was pending a review, an appeal of sorts, correct? She had been sentenced already. Her attorneys appealed her decision. Is that right?
I believe that's right, yes.
Okay.
I don't recall any debate or discussion about the offense level.
I want to take you back to Crystal Mason's case because you've been a little bit slippery on this. And I hope that you don't mean that, I don't mean that to be any negative inference on you, but I want to just kind of pin you down on this provisional versus what you're trying to do here today. You have said many times, if you know you're a felon, if you know you're not a citizen, if you voted in another state, then you would be guilty under your proposed bill, correct?
You could be prosecuted, and if that was proven, you'd be found guilty. I believe it's up to the jury, but I believe that's right. I think that's pretty much the elements in the offense.
Okay, so let's go to September 2nd. Let's fast forward into the future. Now your bill is law, hypothetical, right? I know you don't like hypotheticals. Your bill is law today. Crystal Mason goes to vote. She gets a voter registration, by the way, when she is released from prison. She goes to see her parole officer, gets a voter registration card. Those are the facts. She goes and votes a provisional ballot. I want to be very clear here because she knows she's a felon, but she votes a provisional ballot. Is she guilty under your scenario of Senate Bill 2?
And Senator, her case is the one we've been talking about. That's where the Court of Criminal Appeals came down and changed the law on what the mens rea requirements are. But to make sure I'm clear, now, this is the lady who was convicted in federal court on multiple counts of defrauding the federal government.
The African-American woman, that's correct.
And defrauding her neighbors.
That's correct. The African-American woman. You know, the fact that you want to color this, the fact that you want to color this about her defrauding her neighbors has nothing to do with this, with the instant case of voting.
Senator, if I've been convicted of fraud, as you know, fraud convictions are treated a little more seriously than some convictions.
It's a crime of moral
turpitude. As far as disqualifications for testimony and things like that. I mean, but go ahead.
It's a crime of moral turpitude. That's correct.
Okay.
But you can't, but in a court system, you can't go off and say, oh, she was convicted of fraud. That has nothing to do with this, the alleged offense of voting in this case. Nothing at all to do with that. So I'm asking you now.
It was that conviction that made her ineligible to vote, though, if I'm following you.
And so what I'm asking you now, not asking you about what happened in her case, I'm asking you if your bill becomes law, and on September 2nd, it is the law, and November rolls along, and she now lives in Houston, and she votes for John Whitmire, or she tries to vote for John Whitmire, and she's still on parole. And she knows she's on parole, but she files a provisional ballot. I need to be clear this from you. She knows she's a felon, but she filed a provisional ballot. Is she culpable under your legislation?
So she knows that her voting rights have not been restored after her conviction. I want to make sure I'm tracking.
Yeah.
Knows that and still votes or attempts to vote.
Provisionally, yeah.
The fact that it's a provisional ballot would not vitiate the culpability for knowing my voting rights haven't been restored, and I still try to vote.
Earlier you said something contrary to that.
Well, what I meant to do is, it says in the statute, a person may not, I'm just going to read the statute, that may be what I said, I hope it was. A person may not be convicted solely upon the fact that the person signed a provisional ballot affidavit under 63.011 unless corroborated by other evidence that the person knowingly committed the offense. So in your situation, there's other evidence to corroborate it. Some of the other fact patterns we've heard today, like from Senator Eckhart, the provisional ballot was the only thing out there. I hope I'm
Senator
answering
Johnson
answering your
specifically
question.
asked you about Crystal Mason's case. He just didn't say her name.
Well, I read him the statute just like I did just now. I hope I read it right, but that's what it, and that's the current statute. That's not Senate Bill 2. That's the current statute.
So again, she files a provisional ballot, tells the voter registration clerk or the voting clerk right there at the poll, I'm not so sure I can vote, but I want to file a provisional ballot. Maybe she even says, I'm not even so sure if I can vote because I'm out of prison, but I'm still on paper. That's the colloquialism that people use, right? So she's still on paper, right? And so, but I want to file my provisional ballot. Did she violate your law?
It sounds like she is attempting to vote knowing that she's not eligible to vote. It sounds like to me, it's up to the prosecutor and up to the jury and the judge, but it sounds to me like that would be a problem.
Oh, your inchoate clause. I forgot about that. Attempting.
Well, it says votes or attempts to vote. I'm just, that's the current statute that we're amending by this bill.
I get it. So the attempt piece, she would be guilty of a state jail felony, even though she walks in and says, I'm not sure what's going on here, if I can or can't vote, but I'm a felon. I'm a felon.
And my rights
I'm still on probation, on parole.
Gotcha.
And I just want to file my provisional ballot. Under your scenario, she is guilty of this crime.
Certainly could be found guilty. Certainly could be found that way.
So if she files it as a provisional ballot, then she's facing a state jail felony. I just want to clear that up.
I believe that's what the law says. I believe that's right.
And, we heard earlier from one of your colleagues or another one of our colleagues about the court system and how prosecutors work and how juries work, and we get all of that. And listen, I was a criminal defense lawyer for a heck of a long time myself. We also know that mistake or accident is not a defense, right?
As a rule, like there are exceptions. That's the general rule.
General rule in a criminal case. And so you've talked at length about prosecutorial resources, and prosecutors are going to make decisions about what kind of bills to file, true bills of indictment, correct?
When I was asked about the criteria prosecutors use, that's what I understand they do. I'm not a prosecutor, but the ones who have testified have talked about that. Yes.
In the last 5 years, it seems that 2 African-American people have been prosecuted, Miss Mason and again, Hervis Rogers. Apparently those prosecutors that prosecuted him felt that this was a high crime. And yet, you argue that it is a high crime. You argue, well, we have felonies, first-degree felonies that are, you listed them earlier. Some were of a financial nature. What were they? I forgot.
Illegal barter, expenditure, investment, tampering with direct recording electronic voting machine.
Yeah, and then those illegal barter and the tampering with investment, when we talk about first degrees, they're based on values. They're based on...
Not exactly. Tampering with direct recording electronic voting machine does not have an amount of controversy. Now, there is a list that is based on value: breach of computer security, credit card transaction record laundering, electronic data tampering. Those are based on value. The electronic voting machine tampering is not.
But the legislature thought better last session. And the legislature thought better than to have what almost sounds like a joke. What are you in for? Oh, I beat up my wife, I choked her. What are you in for? Well, I was driving drunk and I put a kid in a wheelchair. What are you in for? Well, I raped somebody. What are you in for, buddy? Oh, I voted. I voted illegally. That's what you want to do, right? That's what you want to do with our state and judicial resources. You want to make that happen, right?
Felony since 1975, Senator.
And the legislature
since
knew
1975.
Better. Fair. But last session, that body over there and this body over here said we're going to make this a misdemeanor.
And here we are again. The legislature makes the laws.
What happened in the last election? Did you see any people voting illegally? Was there some big rush of more African Americans voting illegally or Mexican undocumented? I mean, what happened? Why the rush to change here?
Senator,
legislature made a change.
Let me answer your question.
Sure.
The change was not debated. The change was added, buried in another amendment at the 11th hour. And so it needs to be debated. That's what we're doing today. That's what we do here, as you know.
Got it. So it passed, it became a law, and because you feel, by the way, an amendment by a Republican, but you feel it wasn't debated to your liking, there was no new flock of Mexicans voting illegally or no flock of black people voting illegally in the last election, because I didn't hear of anything. I don't know if you did.
Senator, I don't know if I should dignify that with a response or ignore it. As you know, that's not been part of this debate, nor this bill, nor will it be, nor should it be.
Let's talk about eligibility for assistance. What is that? Section 64031. Every election, there are voters who receive assistance at the polls who don't qualify for assistance. Are you with me?
So far, so good. Yes, sir.
Qualifications for assistance are actually pretty narrow. I want to read you the bill. I mean, the law itself.
Right. See the ballot. Go ahead. Go ahead.
Eligibility for assistance. A voter is eligible to receive assistance in marking or reading the ballot as provided by this subchapter if the voter cannot prepare or read the ballot because of a physical disability that renders the voter unable to write or see, that's number one, or an inability to read the language in which the ballot is written.
I believe that's right. Now, I don't think that section of the code's being amended or is affected by Senate Bill 2, but I believe that is the law.
But you would argue, you would agree with me, it's pretty narrow, right?
Yes. Well, it's pretty clear.
And I know that you suggest that we shouldn't talk about these things, and you're right, but race and culture are important. African Americans have fought for the right to vote for over 150 years, until 1965. You would tell me better, you would know better than me. This has been such an incredible subject matter that you are an expert on. Hispanics, when we vote, we just come from a culture, many of us immigrants to this country. I'm a first generation American. Our families come from countries where you're not allowed to vote as well as you would like. Those freedoms aren't quite there. Older Hispanics that don't have the right that don't have a college education like you and I do, they get nervous. So I want you to imagine someone feeling nervous about voting and requesting assistance, but they know that they don't meet this criteria here. They're just nervous. That little old lady, I think an abuelita, that's grandmother, goes to vote. She's 88 years old. She didn't vote by mail, but she's trying to get some help. But she's outside of this criteria. She can read and she can write, but the clerk at the voting booth says, you know what, I'm going to help this lady out. Is that illegal voting, since it's violating Section 64031?
Illegal voting is described in 64.012, the statute that is being amended by Senate Bill 2. Nothing about it, illegal assistance in there.
Okay, so this is 64031. If someone goes outside of 64031 and gives assistance to a little old lady, is it illegal voting? Yes or no?
Under Senate Bill 2, no.
Fair enough. I got an answer.
You and I both heard testimony about voters, grandmothers, who are taken advantage of, misled by folks claiming to give them assistance. It helps us in my district, and I bet other places in the state, but not affected by this bill at all.
Yeah. Senator Reckhart did a very good job in talking about Jim, the college student. I'm just about done. We did a tremendous amount of work on redistricting last session. We redistricted even down to the county commissioner level. Is that not right? We approved certain maps. I mean, in our communities, not us, but our county commissioners did. We did Senate maps. We did House member maps that we approved, congressional maps, correct?
Right.
And then our local counties, they do county commissioners maps. And then the city council will do their own kind of sort of redistricting in their communities. Is that fair?
I believe that's right.
All right. So if someone knowingly voted in the wrong county commissioner precinct because their map got switched up a little bit, did that person vote illegally?
It doesn't sound like that person would knowingly or intentionally vote in an election on which they're not eligible. It would depend on the facts. I'd like to hear a little more about the hypothetical, but it doesn't sound like it.
Well, I hope that doesn't happen in Montgomery County or the other one next to Tarrant or wherever that was. Senator Hughes, thank you very much. I appreciate your time, and thank you, Mr. President.
Senator Hughes moves suspension of the regular order of business on Senate Bill 2. Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez.
There be 19 yeas and 12 nays. The rules are suspended. The chair lays out on second reading Senate Bill 2. The secretary will read the caption.
Senate Bill 2, relating to conduct constituting the criminal offense of illegal voting, increasing a criminal penalty.
Following amendment, secretary will read the amendment.
Floor amendment number 1 by Hughes.
Chair recognizes Senator Hughes on the amendment.
Thank you, Mr. President. Members, the amendment before you is one that I think Senator Miles and I discussed. I may have mentioned it to Senator Whitmire during the hearing on Senate Bill 2 here on the one of the witnesses, there were questions about whether voters would know the circumstances. One of the witnesses suggested, why don't we put up signs at polling places just giving people notice of what the law is? A couple of members said, yeah, that sounds like a good idea. That's what this amendment represents. It came from someone who testified, and I'm happy to discuss it. It's very straightforward. Election officers are supposed to sign listing the particular circumstances that make a person not eligible to vote, including the types of criminal convictions, in one or more locations in the polling place where it can be read by persons waiting to vote. Just tracks the statute. We think it's just to give people notice and directed at some of the potential mistakes we've talked about today. That's what the amendment does. I move its adoption, and of course, yield for questions.
Senator Mendes, for what purpose?
Thank you, Mr. President. Would the gentleman yield for questions?
For Senator Hughes, will you yield?
Of course I yield.
You're recognized.
Thank you, Senator. So I think this amendment on its surface is an amendment, as you've described it, that you're just trying to inform people of what may be or may the case or may not be the case. My concern is, and this is one of the things, I don't think this is your intention, is it your intention in any way, shape, or form to deter people from voting?
Senator, of course not. This is for folks who are, in fact, it says in the polling place where folks are waiting, where persons are waiting to vote. So I'm there to vote, and this is for me to see in case maybe I am curious. Maybe somebody didn't know that not being a citizen made them ineligible to vote. Maybe they didn't know that having that felony conviction made them ineligible. Maybe they didn't know that being registered voting somewhere else made them ineligible. It's just about giving people notice. It's nothing more fundamental to due process than notice.
Sure. I think the concern that I have is I'm not sure if you're aware that recent elections, there's been over 267 reports of voter intimidation in Texas. Are you aware of that?
I'll take your word for it. I believe you.
So one of the reports states here that there was a precinct chair knocking on people's doors, accusing them of illegally voting by mail, even though they were clearly eligible to vote. So my concern with your amendment is that it could be pointed to by someone and said, you know, anything on this list of things that could potentially cause you to not be eligible to vote, you could be facing, if your bill passes, a second-degree felony. Would that be an accurate? That's what the new penalty that you're proposing. Is it correct?
Senator, that's correct. And of course, as you know, regardless of whether the penalty is restored to what it was for 50 years, these are crimes today. Without Senate Bill 2, these are crimes under the Election Code. So we'd be giving people notice of what the law is. Regardless of the penalty offense.
No,
this is about letting people know.
I understand. I think that the concern that I have is that there are many reports of voter intimidation in Texas, and we're hearing from voters experiencing harassment at the polls, and this would almost be state-sponsored in the sense that under the guise of we're just letting you know, if you fall under one of these things, you're not eligible to vote. Your amendment doesn't dictate what the penalties are, does it?
So the details would be delegated to the Secretary of State to have the form and content of the sign, but it's letting people know, again, particular circumstances. That's the language we've been talking about a lot this afternoon. Those circumstances that are listed in the statute that would make you ineligible, but nothing about the penalty here.
So would you be, I guess one of the concerns that I have that I can envision is that now that we have, I think it was the Senate Bill 1, did it not allow for poll observers, watchers, whatever the term is, to be able to roam freely where they can see people voting? Is that correct?
That's right. They've never been able to allowed to watch the voter casting their ballot, but there was a discussion about whether they should be able to go to other areas of the polling place. But they've never been allowed to watch a voter cast their ballot unless there's a question about assistance, like Senator Senator Gutierrez was talking about.
Right.
Go ahead.
So the concern is that with these signs, the poll watchers would then be able. I could envision some of them saying, if you happen to possibly be on that list or have done something, you could face second-degree felony, a 2 to 10-year penalty. I just see that earlier you said something, I think it was between your exchange between you and Senator Huffman, that prosecution under this law would probably be difficult. You agreed to that, did you not?
Well, so I referred to testimony from a prosecutor that said without Senate Bill 2, it would be virtually impossible to prosecute the cases. And then Senator Huffman said even under this law, it would be tough to prosecute. I think that's what she said, and I'll defer to her.
That's what I heard as well. And so I guess my concern is not so much that someone who makes a simple mistake does get prosecuted. I am very concerned for the scenario where we had the 17 about to turn 18-year-old who signed the registration instead of 17 and 10 months, 17 and 9 months, or 8 months. Now, eligibly, he could be prosecuted. But more than that is we're now going to be posting, here are all the reasons why you shouldn't vote. And I agree that people need to know. But my concern is that it be used as a deterrence to vote, an intimidation to vote. And I know that's not your intent, but I think that's how this could be used. And so that's my concern with this amendment. So I think that it'll be very interesting to see how it's drafted, how it's posted, where it's posted. I think it's going to be potentially something we need to be thinking about. I'll close with this. Are you aware that in the last 10 years, Texas has closed over, I think it's almost 700 polling sites? Were you aware of that?
I know there's been a lot of changes in polling locations. We've had discussion about that, where in some counties it looks like they might be closed to help one party or the other. But I know a number have closed. I didn't know the number, but if you say 700, I'm sure you're right. I believe you.
Well, I mean, Mr. Chairman, I'm just looking at these facts, and when I looked at the 2020 general election in terms of the the top counties in the state of Texas with reports of voter intimidation, would it surprise you to know that the number one, I'll list the top 5, Harris County, Tarrant County, Dallas County, Montgomery County, and Bexar County. Those were the top 5 that listed reports of voter intimidation. Just about almost all of them, maybe with the exception of one, are urban counties. And so I'm worried that the cumulative effect of this legislation with this amendment, and then I know that there's also bills in this chamber that have been filed to take away mail-in ballots. Now we have more people going to be taken out of their homes, asked to come vote, with these lists of things that these are the reasons you can't vote. And this is even more cause for concern. Thank you for your patience and listening to my questions. Thank you, Mr. President. Thank you, Mr. Chairman.
Thank you, Senator.
Senator Miles, for what purpose?
Will the author yield, Mr. President?
Senator Hughes?
Of course I yield.
You're recognized, Senator Miles.
This is the one I was talking about, Senator. Go ahead.
Yeah, and this is the one I told you I wouldn't vote for. Senator Hughes, you know, Senator Menendez had concerns. I have more than concerns. Because as I read this, and the key word being type of criminal convictions, this is, let's call this what this really is. This is intimidation. This is voter suppression. This is going to deter a sign on the wall that says criminal convictions in my community is going to scare people away. It's not going to welcome anybody. It's not going to inform anybody. It's not going to educate anybody. It's going to scare them away. This is pure intimidation and voter suppression, Senator Hughes. And I'm going to call it what it is.
But Senator, if it's
Senator, there's nothing
the
you
law,
can say.
and I'm really trying. I'm trying to understand. Keep going, please. I didn't mean to interrupt you. Go ahead.
Senator, there's no way you can explain that this is going to educate and help individuals. This is not going to do anything but scare people away. Okay? Do you read the fine print on the back of your movie tickets? Have you ever read the fine print on the back of your movie ticket?
Rarely.
Who do you think is going to read the fine print on a poster? And how big is this poster going to have to be to list every criminal conviction that can deter somebody or keep somebody from voting? How big is it going to be?
Well, Senator, we've spent a couple of hours talking about people who don't know that a circumstance might make them ineligible. This is an attempt to address that.
But Senator,
this came up at the hearing.
in my community, it's not going to address this. It's going to scare more people away from voting. When we should be trying to get more people to the polls, okay, when we should be fighting, both parties should be fighting, not just one party. Both parties' numbers are low in the state of Texas. When we should be fighting to get people to the polls, you're going to come up with this that's going to scare not just my Democrats, but I guarantee you it's going to scare some of your Republicans as well, because some of them got some criminal convictions as well. Okay? This is not helpful. This is a hindrance, and it's going to deter people of all parties from coming to the polls and voting. Thank you, Mr. President. Thank you.
Senator Hinojosa, for what purpose?
Well, Senator Hughes, yield for a few questions.
Senator Hughes, will you yield?
Well, of course I'll yield.
Senator Hinojosa, you are recognized.
Thank you, Mr. President. You know, I'm somewhat conflicted by this amendment, only because I think notice is to people is always good. But as I read your amendment, shall post a sign listing the particular circumstances that make a person not eligible to vote. How many of those circumstances do we have?
Well, Senator, it's the reason that language is there because in the statute and in the amendment it says of a particular circumstance that makes a person not eligible to vote. So that's the idea. So not being a U.S. citizen, having a felony conviction which has not been, you've had your rights restored from. So we're talking about those underlying facts. And of course, the statute lists, if you're registered in another county or if you have already voted in another place in this same election. So they're listed in the illegal voting statute.
So how many are they?
So there are, let's see, there are five subsections, and then of course we talked about the qualifications to vote. That's U.S. citizen and no felony convictions that you haven't fully completed your still on paper for. Go ahead.
I'm asking, do you know the number of circumstances total? Is it a dozen, 10, 15?
I see what you're saying. No, the idea is that when we tell folks here, if there are circumstances that make you ineligible to vote, not being a U.S. citizen, having a felony conviction.
No, I know what the idea is and what you're trying to do. All I'm asking is a very simple question. If you don't know, say you don't know.
Okay.
I'm trying to find the total number of circumstances under which a person cannot vote that you are requiring by this amendment to be listed.
I see what you mean. It would track this. It would track the language of the statute. So as close as possible, we would expect them just to quote the statute. That'd be my preference. And if it gives, of course, the discretion goes to the Secretary of State, but it's just asking them to track the statute.
Okay, so you don't know the total number?
No, sir. It would just be required the language of the statute.
That's what I'm asking.
Yes, sir.
Just pretty much answer my question. Now go around it.
Yes, sir. Doing my best.
And here's, you also, in the voter ineligibility notice, you also have included the types of criminal convictions. What types of criminal convictions are we talking about? How many are they?
Senator, as you know, and it kind of goes to Senator Miles' question, because as you know, every criminal conviction does not affect one's voting rights. Now, under the law, when I'm sentenced, either after a trial or because I pled, then the judge has to tell me if it affects my voting rights, because some criminal offenses do not. It's generally speaking, it's felonies, but that's the idea, to give people notice, as you say.
I understand that too, very well. What I'm asking is, how many types of criminal convictions are there that would make a voter ineligible? You don't know? You don't know.
I think the point is, felony convictions, which are what we've talked about today, those are the ones that affect one's voting rights. And the judge has to tell you that when you're sentenced. The idea would just be to have notice at the polling place so folks aren't confused.
I know procedure very well, Senator Hughes. I know the procedure very well.
Okay.
But what I'm asking is, and if we don't know the number, that's okay too.
Felony convictions.
That basis types of criminal convictions. What types are we talking about? How many are we talking about?
Right. And the point is, of course, felony convictions. The point is, to Senator Miles' point, every criminal conviction does not affect one's voting rights. That's kind of the idea, to let people know it's felony cases that are at issue. Is that what you're talking about?
Yes, sir.
Okay.
Which felony case are we talking about that would make a voter ineligible to vote? We got to post it. We got to list it and tell them what felony conviction we're talking about.
Right. Felony convictions are what we've discussed most of today. I think that's the primary concern.
Senator Hughes,
we can.
If you don't know the answer, that's fine.
Felony convictions is what we're talking about.
But there are different kinds of felony convictions, are there not? Are all felony convictions makes a voter ineligible to vote?
That's the rule, yes. Yeah. As you know, once you complete your terms, your voting rights can be restored.
And the reason I ask this question is because, as you know, at voting precincts, it's very chaotic during election time. It's very chaotic during election time. And how big is the notice be? That's what concerns me. You have a long 1-pager, 2 pages, 3 pages. That's why I'm asking the total number of those felony convictions you're talking about, or the circumstances you're talking about.
I understand what you're asking. Sometimes when we require notices, like on the handgun license, the statute is very prescriptive what it has to include. Other times we delegate it to the agency. Under this amendment, the Secretary of State would work out the size and the font so that it could be read. But if you want to try to figure out the details on the floor, we could do that. But normally, those are delegated to the agency.
Well, I guess when in doubt, vote no. But I have some concerns that we're placing this extra responsibility on election sites. As it is, there's already quite a bit of back and forth intimidation. But thank you, Senator Hughes, for
thank you.
trying
Thank
to
you,
answer
Senator.
my questions.
Senator Whitmire, for what purpose?
President, will the gentleman yield?
Oh, of course I'll yield.
Senator Hughes will yield. Senator Whitmire,
First,
you're
let me
recognized.
preface my remarks. I think you're dealing in good faith. I think you're trying to address a concern that almost a dozen of us have probably raised in the last 2 hours. But if I could convince you that it's not appreciated, not wanted by those that are concerned about just the uninformed voting and being prosecuted, would you pull your amendment down?
Senator, thank you for that, and I appreciate what you...
For instance, you're from Tyler.
Yes, sir.
Fairly homogeneous community. Probably most people know one another. Then you get to my community, an urban setting, very diverse. Recent years, we've had instances where with the clear intent to intimidate folks, on Election Day, folks bring up Suburbans that look like Border Patrol vehicles. I mean, there's been an effort to have warning signs at the polls, and this is where you're headed if you don't understand where we're coming from. There are clear, convincing examples of folks deter people from voting, suppress the vote, and with your instructions and warnings, I think it's all about implementation. I could foresee someone with an ill intent having warning, big bold red line, lettering, do not enter if you are a convicted felon and your felony hasn't been cleared. If you're not a U.S. citizen, I can go on and on, and all well intended, but boy, I could see some ill will folks trying to deter folks from voting. So as good as your intentions are in addressing the concerns that have been brought out today, I really think there are unintended consequences that perhaps you haven't considered. And so I think it's a good faith effort on your part, and we don't like to vote against your good intentions, but we're going to be forced to because we've seen it misused before. So you get that provision in the hands of the wrong person, it could be a tragedy.
Well, Senator, thank you for that. And as I respond, let me answer Senator.
Have you considered those unintended consequences?
Yeah, let me respond this way. Yes. As I reply, I want to also answer Senator Hinojos' question. The list is on the Secretary of State's website. It would say you're eligible to vote if a U.S. citizen, resident of the county where you submit the application, at least 17 years old and 10 months when you registered, 18 on Election Day, not a convicted felon, not been declared by a court exercising probate jurisdiction to be either totally mentally incapacitated or partially mentally incapacitated without the right to vote. So that's what the list would be based on the statute. But I certainly understand what you're saying, Senator. And again, this idea of a notice was not in the file version of the bill. I'm getting to my answer. Was not in the file version of the bill. This came up, Senator Miles, this came up at the hearing. A witness, an election worker, suggested this, sounded like a good idea. But Senator, I'm getting to my answer. I'm going to withdraw the amendment. It responds to about 2 hours worth of debate, but I'm going to withdraw amendment number 1.
Thank you.
Senator Hughes withdraws amendment number 1. Following amendment, Secretary read the amendment.
Floor amendment number 2 by Gutierrez.
Yes. Thank you, Mr. President. Mr. President, members.
Chair recognizes Senator Gutierrez.
Thank you, Mr. President. Mr. President, members, Senator Hughes, what this amendment seeks to do is, it might just be redundant, It might just be exactly what Senator Hughes has told us that is already anticipated in the code. What it does, it makes it an affirmative defense to prosecution under this section that, one, the person's ballot was not finally counted. In other words, a provisional ballot. I'll tell you why that's important. As you all well know, about 98% of provisional ballots are not counted. Number two, there's an actual affirmative step that the voter has to take to cure it up down at the elections office. Or sometimes you have a verification committee that tries to cure up the provisional ballots. But in rare occasion are these darn things ever even counted. The second provision that it does is that the person engaged in the conduct, it's also an affirmative defense, if the person engaged in the conduct constituting the offense at the direction of an election official, including by being issued a registration certificate under 13142. Why is this important? It's important for the very reason that someone might be in violation. I know that Senator Hughes suggests to us that the violation of 65031 is not envisioned in his notion of SB2. And so by adding this amendment, we ensure for ourselves that no other violative offense in another section of the code would be considered as violative of SB2. In other words, keeping us within his enumerated provisions. And lastly, it would also be the affirmative defense within that same section of Section 2 that the person engaged in the conduct, including by being issued a registration certificate by a third party, but in other words, a registrar. And so in these instances, if we're truly about safeguarding the franchise, if we're truly about making sure that we're not utilizing our prosecutorial resources up, if we're truly about making sure that we want to make sure that people aren't voting illegally, in other words, people that are voted in another state, not a citizen, if you know you're not a felon, that this is yet a further protection of people that make an honest mistake. And so if you want to protect people that made an honest mistake, you want to vote for this amendment. And with that, I yield for any questions.
Senator Eckhart, for what purpose?
Ask questions of the author of the amendment.
Senator Hughes, Senator Gutierrez, do you yield?
Yes, sir.
So, Senator Gutierrez, so E1 is pretty self-explanatory. The person's ballot was not finally counted, so kind of the no harm, no foul defense.
Yes, ma'am.
Now, the second one, E2, the person engaged in the conduct did so at the direction of the election official, including by being issued a registration certificate under 13.142. Doesn't the election code under that section aren't applications to receive that certification, don't they require the applicant to swear that they are eligible and asks them point blank all of the questions that are intended to prove up their eligibility to vote?
Yes, ma'am, I believe that they do.
And then under that same section 13 of the Elections Code, isn't it the election administrator's obligation to verify before providing the certification?
Yes, ma'am, I believe that that's correct.
So thank you very much for this amendment. I think it's a very good one.
Moreover, Senator Eckhart, if I may add, your question about the young man in college, and the response that we got is that it likely wouldn't offend Senator Hughes's interpretation of SB2. And my question about 64031, I believe, 64031, eligibility of assistance. If we go outside the very narrow sense of eligibility of assistance, I think Senator Hughes says that it wouldn't be violative of SB2. No offense to Senator Hughes, I don't want to rely on his assertion, that it wouldn't be violative of SB2. I would rather have a protection in place that takes care of innocent people and doesn't put them in the peril of being sent to prison with violent sex offenders. Thank you.
And to that point, I have one more question for you because you raised an interesting issue. With regard to having made the application, there are criminal offenses to making an application with false information. So it seems almost to be a double jeopardy.
Yes, ma'am, you make a very good point in that sense.
Thank you.
I move adoption of the amendment, Mr. President.
Senator Hughes, on the amendment.
Thank you, Mr. President. As to the section of the code that Senate Bill 2 would amend, I don't think it's confusing. The current election code says 64.012 illegal voting. And it's got 5 subsections. That's the only section that we are amending in Senate Bill 2. There's no reference to any other offense in the election code. And there are many offenses. Illegal assistance is a separate offense from illegal voting. And so I think that would confuse what the bill is about. And then I would say this, as far as under this amendment, if someone is not a U.S. citizen and they're somehow able to get a voter registration, somebody slips up and registers them to vote, a non-U.S. citizen would be allowed to vote under this amendment, as could someone who's a felon who's not completed their terms, or for many other offenses, just because somebody slipped up and allowed them a voter registration. So respectfully, I'll be voting no on this amendment.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell, Creighton, Eckhart, Flores, Gutierrez, Hall, Hancock, Hinojosa, Huffman, Hughes, Johnson, King, Colcourse, Lamantia, Menendez, Middleton, Miles, Nichols, Parker, Paxton, Perry, Schwertner, Sparks, Springer, West, Whitmire, and Zaffarini.
There will be 19 nays and 12 yes votes. The amendment fails. Senator Hughes, you're welcome for a motion. You're recognized for a motion. Sorry.
Thank you, Mr. President. Members, I think it's clear what this bill does. 2 discrete changes that restores the law to where it was before 2021. It's been that way for almost 50 years. Courts have interpreted it that way. It makes sense. It's consistent with other criminal statutes. And so I move passage to engrossment, Senate Bill 2.
Secretary will call the roll.
Alvarado, Betancourt, Birdwell, Blanco, Campbell.
19 ayes, 12 nays. The bill passes to engrossment and will hold there. Thank you.